A question and a further point of discussion about Huw Edwards. First of all, the question. A few people now actually have asked, why was he in the Magistrates' Court and not the Crown Court, where there's a more severe penalty? The simple answer to that is the Chief Magistrate kept the case. You see, the cases like this go through an allocation process whereby the Magistrates' Court will decide whether or not to accept jurisdiction, as we call it, i.e. does the case stay at the Magistrates' Court or does it get sent, is the term, to the Crown Court. That can be for a number of reasons. It can be the complexity of the case. It can be the likely sentence. It can be whether the Magistrates' Court can indeed try the case. Obviously, the Magistrates' Court wouldn't try a murder case. And so in this case, the magistrates kept this case about Huw Edwards. Maximum sentence could have been a maximum of 12 months. That is because there's a maximum at the moment, at least. There's been some to and fro in the past, but at the moment there's a maximum of 6 months per offence and a maximum of 12 months with more than one offence combined. And of course, in this case, it was a 6-month suspended sentence. So that's the somewhat vague, I suppose, answer to that question, is that the Magistrate Court kept this case and did not send it to the Crown Court. He could have elected Crown Court if he was standing trial, but obviously he pleaded to the offences. Now, the other comment for discussion, really, is that there is no real punitive element to this sentence. Now, as an interesting point of trivia, above the Old Bailey, there's an inscription which says, "Defend the children of the poor and punish the wrongdoer." So there is essentially supposed to be a punitive, a punishment element to these sentences, which is designed as the deterrent, as many people have obviously seen with people going to prison for what they post on Facebook to incite violence and so on. They've been sent to prison for those things as a deterrent to prevent other people from doing so. But let's look for a moment and analyse this. Now, once again, this was 12 months for one offence, 4 months for another, 2 months for another to run concurrently. However, taking the mitigation into account, reduced to 9 months, applying credit, reducing further 3 months to 6 months, and then suspended. So one might argue that a suspended sentence is a punitive sentence, but it isn't in the sense that he didn't actually go to prison. Now, you might have noticed as well this in the sentencing remarks regarding mitigation. It says, "I'm of the firm view that the combination of being forced to confront your wrongdoing in a very public way, you're seeking your professional help, and the supportive blanket which that and the input of probation will provide within the suspended prison sentence with requirements will rehabilitate you and thus strike a balance between public protection and rehabilitation." And then it says, "Whilst grateful for the report and understand the logic, I disagree with the author of the report. I don't consider that a structured program is necessary," etc. And then went on to suspend this sentence. Consequences of breach, and even discussing a harm prevention order, deciding ultimately that it's not necessary, and having regard to the Sentencing Council guidelines and ancillary orders, an order made alongside any primary sentence, says the details of the offence are likely to be a key factor together with the offender's previous convictions and the assessment of risk presented by the probation service in any pre-sentence report. Although the probation officer expresses the risk as being medium, I have regard to conclusions of both experts, and ultimately concludes and says, I am satisfied on the balance of the evidence before me that an order is not required in order to minimise the risk of harm to the public or any particular members of the public, is not proportionate in the circumstances. I think there's an edit been lost there. Given the protective impact of the sentence and his continued assistance by mental health services, although it could be policed effectively. That doesn't entirely make sense to me. I mean, essentially what it's saying there is because he's subject to this suspended sentence order and continued assistance by the services and the mental health services, that it's not necessary to make a serious a harm prevention order. And then says, I do not conclude that I'm satisfied that the defendant presents any such risks of harm to the public, or that it would be in all the circumstances necessary to protect against that risk. This is clear on the evidence. When read as a whole and not selectively, I decline to make a harm prevention order. As I've said in the previous video, I don't think many people are going to agree with that. Not to say the judge is wrong, but I don't think many people will agree with it. And just to say as well, my learned friend Alan Robertshaw's done some thoughts on this as well. I will link that in the description below and I'll pin a comment. But the one thing that jumps out here is that there is no real punitive element to any of this sentence. Now, I know a lot of people, particularly I suspect criminal lawyers, will argue and say the suspended sentence order is a punitive element to the sentence, but it isn't really, in the sense that he's not actually going to prison. He'd be liable to go to prison if he doesn't comply with these requirements or he does anything else, which he shouldn't be doing in the first place. If he commits any other offences, then he'd be recalled to prison for this offence and the new offence, if there's any new sentence. But apart from that, there is no punitive element to any of this. Now, he's been asked to pay costs, a contribution towards prosecution costs of £3,000. I can fairly categorically say it would have cost more for this whole process than £3,000. And a statutory charge of £128 within 14 days. I make a collection order in default means the court can take enforcement action if you fail to pay, etc., etc. But let's be honest, £3,000 for someone with the money that I presume he has is not really a punitive aspect to all of this. That's just some costs. Everyone pays costs if they lose a case, civil or criminal. But apart from that, it does seem rather strange that there is no actual punitive element. Now, a lot of people might disagree with the sentencing guidelines and the process and the sentence and everything else. And so Al's got some more thoughts on that. I'll link his video, as I say, below. Go ahead and watch that. But as I say, a lot of people have commented that there doesn't appear to be any actual punitive punishment element to this sentence. So I can't explain that other than what I've read out from the sentencing comments. But what I can say as well, which relates to both really, is that these were already prepared, which sort of suggests that he'd already made his mind up, which does raise a question as to how much mitigation really plays a part, which we might discuss in future videos. So subscribe to both me and Al at Art of Law below, and we'll discuss that in future videos. Now, of course, if there were strong mitigation on the day and etc., this all might change. But it seems to me that this was all analysed very thoroughly and before the hearing. Because obviously, whilst this was dated yesterday, it is 16 pages long. So doubtless will have been at least in bulk prepared ahead of time, thus staying within the limits of the Magistrates' Court for sentence and handed the sentence that they did. But as I say, I think a lot of people have different thoughts and comments about this one. I will leave the comments on to this video. And so let me know what you think. Please do subscribe and I'll see you next time.